Welcome, and thank you for joining us for today's webinar. My name is Santiago Marino, and I'm a content creator here at DoorLoop. I see some people are still joining, so while they do that, I would like to remind you that in this webinar, we're going to go over general information, and we cannot give you any legal advice or financial advice. So if you have any specific legal questions, we are going to share our guests' contact information at the end so that way you can reach out to them directly. All right. And as you know, DoorLoop is a property management software solution, and we help landlords and property managers manage their real estate portfolios. Now, because we get so many questions about landlord-tenant laws, we decided to bring in an expert and real estate attorney. So today, we're super excited to be joined by Gregory Spadea, a licensed attorney from the state of Pennsylvania. Thank you very much for joining us today, Gregory, and welcome to our webinar.
Well, thank you for having me today. It's nice to be here.
Our pleasure. Thank you very much for taking the time to join us today. And why don't we start off with sharing with everybody a little bit about your practice and your experience as an attorney in Pennsylvania.
Okay, yeah. So I opened my practice in 2001, and I'm in southeastern Pennsylvania in Ridley Park. We are moving our office in October to Folsom, which is a mile from our current location, but we'll still be in
Nice.
Delaware County and in Ridley Park. And we handle basically landlord-tenant matters in southeastern Pennsylvania, which includes Montgomery County, Philadelphia County, Chester County, and Philadelphia County. So those are the main counties that we operate in. In addition to doing that, we also do estate administration, estate litigation, and tax law and tax controversy work.
Oh, fantastic. And I see we have a little bit of your resume, or rather your bio here. It seems like you were an IRS agent and a certified public accountant in the past. Do you have any interesting stories about that?
Yeah, I always like to tease my friends and say I was on the dark side for many years. Actually, not many years. I
Interesting.
worked for IRS for 13 years. So for 13 years, I was on the dark side. But in all seriousness, it was a great background because I do represent clients in tax court. We also prepare tax returns year round for individuals as well as for trusts, corporations, and partnerships. So it's served me well in my legal career, and I enjoy tax immensely, but because it runs through everything. But I also enjoy,
Mhm.
real estate matters like landlord-tenant and doing leases and stuff. So it's
Yeah.
pretty exciting.
Terrific. Thank you, Greg. And I also see that you were in the Army for some time. So I definitely want to thank you for your service. Absolutely.
Yes. I retired in 2012, and as my way of saying thanks to all the veterans out there. If you live in Pennsylvania, New Jersey, I do free wills for veterans, which is a $400 value. So you can obviously at the end, my contact information will be there. Feel free to contact me, and I'll be happy to help you out. I also serve as the treasurer, which is called the quartermaster at the local VFW post 928 in Folsom, Pennsylvania. I've been doing that for the last 2 years, and I enjoy that immensely because it's definitely I love to help veterans, and the VFW is a great organization to do that.
Gotcha. Well, that's amazing. And I'm sure anyone who's a veteran will definitely be interested in that. Really glad you're doing that. So let's jump into a little bit of the agenda that we have for today. Today we're going to be talking about screening prospective tenants, as well as having a good residential lease, limiting your liability as a landlord. We'll also talk about grounds to evict a tenant and about the eviction process. We will also touch on tenant rights and squatters' rights laws. And at the end, we'll finish up with talking a little bit about rent increase laws in the state of Pennsylvania. All right, so let's go ahead and stop sharing the screen now. And let's get started with screening prospective tenants.
Okay, and this
Yeah, go ahead.
probably this and this is really the most important thing. I have a lot of clients that are landlords, and the most important thing I tell all my clients is, you got an ounce of prevention is worth a pound of cure. I really think that's a great analogy, and that really sums up why it's so important to not just get when you have a prospective tenant. There's a rental application actually on my website that they give out free to anyone that wants it on the resource page. And basically, on the rental application, you're going to make sure that you have the tenant, the prospective tenant, I should say, when they apply for to be a tenant and they fill in the rental application, you're going to get their social security number. You're going to get their current employer's information, their supervisor's name and phone number, their current landlord's name and phone number if they're renting from someone already. And you're going to get their permission to pull their credit report and criminal background check, which is also very important. And I always tell my clients, if the credit report, if they check out every other way, but they have a low credit score, typically I recommend that they want to have at least a 600 score. But if they have a score below 600, but they have a very good reason for it, like for example, if they just got divorced and because of the divorce, their credit took a big hit. If they've got a good reason, I'm willing to overlook that one aspect of the application and still allow them to be a tenant if they've got a good reason. Now, obviously, if they say I got a big credit report because I didn't pay my bills, that wouldn't be a good reason. And then I wouldn't overlook that. That would be a no-go. So, but anyway, and also for first-time renters that don't have a prior landlord, a strategy that I use is typically I do a 2-year lease, and leases, I do sell leases to my landlord. So at the end of this presentation, if anyone wants a good Pennsylvania lease, feel free to contact me, and I'll be happy to help you with that. But basically, on the good lease, if it's a first time tenant, don't be afraid to get their parents to co-sign for them for the first 1 year or 2 years of the lease, because they don't have any history of renting. And this way and also if they have a lower credit score than you're comfortable with, it's a way to make sure that someone else will be liable that's got a better credit score and that has the resources in the event they don't pay and you've got to evict them. So, and again, when you get that credit application, you as the landlord should contact the prior employer and the current landlord yourself, and make sure that these folks are good employees and that they're good tenants, because a lot of landlords don't do this. They delegate it to a property manager, and if the property manager doesn't do it, you're going to be jammed up, and I don't want to see that happen. So again, I really stress that all my landlords don't delegate that. You yourself needs to be making that phone call to the current employer as well as to the current landlord, and just make sure they're a good tenant, make sure they've had the job for at least 3 years, they're a good employee, they on time every day, they don't show up drunk or high or anything, because you don't want to have any of those issues. You want to make sure you identify them before they even, you allow them to rent from you. Now, in addition, after they pass they've contacted their current employer and their current landlord, you're ready to rent to them. Again, you want to have a very good lease, because basically that is very, very, very important. And I don't recommend using the Pennsylvania form leases that you buy at Staples or online, because they don't have a lot of critical things. Like, for example, Act 215, which is in every lease that I do, says that you as a landlord, if you win a judgment against a tenant, you can then garnish 10% of their wages. And that also goes back to after they rent from you, an addendum to the lease that I use also says that they got to give you their current pay stub every year. So if they switch jobs, you need to know about it. So if you later have to evict them, you've got their current employment information. You're not searching for it. And also it's very important that they have renter's insurance for the contents. So, and you want to require that. Don't make that optional. It's very inexpensive. It'll cost a tenant like $300 a year. And then God forbid, if there's a fire or a flood, all their contents will be covered. They can get a brand new TV, new furniture. It's damaged. So that's very, very, very important. So
basically limiting your liability as a landlord with the lease, with screening. It's all about trying to save time and money in the future, and headaches, most likely.
Absolutely. And like I say, at the very beginning, I said, that ounce of prevention is worth a pound of cure, and that's a
Right.
great example. The
Absolutely.
and finally, in the lease itself, I'll just go over this one last item.
Sure.
My lease actually put a dollar amount for legal fees. So the tenant's
Okay.
going to agree that if you as a landlord have to sue them and have to hire
hmm
me or another attorney to sue them, in the lease that I do, it actually has a dollar amount. It says that the tenant agrees to pay the landlord $1,750 of legal fees if we have to sue them in district court, in the counties or in municipal court or landlord-tenant court in Philadelphia. So basically, the reason why that's important is if there's a
hmm
dollar amount in the lease, the
Right.
district justice has to give you that dollar amount. He can't give me. I just went to landlord-tenant court last week. I was awarded
hmm
$300 in legal fees. The client paid me, $1,750. So clearly, the client's eating that difference because he didn't have a good lease. So again, I really want to make sure that don't be afraid to have a really good lease, because the better your lease is, the more protected you'll have. And we go back to, again, eliminating your liability as a landlord and making sure you're protected. Now,
Right.
the next item that I wanted to go over is the security deposit.
Right.
Yeah, if the tenant is, and this we're actually going to cover this. We might cover it later in the eviction process, but I'll
hmm
cover it right now briefly. And that just simply
Yeah.
is, if the tenant does move out, or at the end of the lease, let's say you don't evict now, let's say the lease ends, the tenant gives you the proper 90 days notice, or you give the tenant 90 days notice to vacate. They say, no problem, we're happy to leave after 90 days. The day comes, they tenants vacate. When you as a landlord do the walkthrough with the tenant, make sure you take pictures of the entire
Right.
property. And as the tenant, you should do the same. Make sure you both the tenant and landlord should both take pictures on their own phones. The reason that's very important is, if the tenant says, "Hey, that was broken when I came here," let's say there was a hole in the wall when I came
hmm
here, if they can prove that when you first move in, if you're a tenant, you should also take pictures of any damage and immediately
Always.
the landlord. Because
hmm
what you don't want to have happen is, you don't want to say, "Oh my goodness, the landlord's making me repair a hole in the wall that was there the whole time I lived in the property," and that's not a good feeling for the tenant. So you
Right.
want to make sure that happens, and then when you're the tenant, when you move out, you have to give the landlord your current forwarding address. If you fail to give the landlord your current forwarding address when you give him the keys and you turn over the property, he can't give you, he's got nowhere to mail the security deposit. And he's
Mm.
got 30 days to do that after you give him the keys and your forwarding address. So that's very important. I get a lot of phone calls, with that exact issue from tenants saying, "Hey, I moved out 2 months ago. My landlord never sent me my security deposit." I said, "Well, did you give him your address?" "Oh, no, I didn't do that." "Well, then how the heck is he saying it?" So
Of
obviously,
course.
you want to make sure that you give the landlord a forwarding address. The landlord's got to do as required by law. If they
hmm
don't give you the full security deposit in 30 days, they got to give you a letter explaining why they didn't give it to you. So, for example, they need to give you an itemized list of repairs that they're applying the security deposit to. So that's very, very important. So again, I just wanted to make sure that I covered that, because I get that
Got it.
question a lot. And
That's a
then,
great point. And a quick question, Greg. One thing that I've noticed that sometimes landlords may, as far as the pricings that they use on those lists, they'll put in like $100 to get rid of a bag of trash. Like how can they be as careful as possible in order to make sure that those items that they're, charging the tenant are actually legitimate and not just exaggerating?
yes, that's an excellent question. I think that I always tell all my clients that are landlords, I always say, if you've got to pay. So here's the real thing. If I am a landlord and I actually spend 2 hours removing all the trash from the property, a lot of times in the lease that I do, I write in there, I say, if you leave any property after you turn over the keys, or if you abandon the property and don't come back after a certain period of time, the landlord, it treats you, or if I evict you and you abandon property after I get the order for possession, basically, I typically put in 10-day rule. I say, you've got 10 days to come back and get your stuff. You don't get your
Okay.
stuff in 10 days, it's considered abandoned. I just throw it in the dumpster. Now, if you voluntarily left and we agreed you're going to leave on this date, and we do the walkthrough together. When we do the walkthrough, if I say, "Hey, there's trash here," and I tell you, you should remove it before you leave, and you fail to remove it,
Mm-hmm.
then if I pay someone to remove it, whatever I pay them is what I'm going to deduct from your security deposit.
Got it.
If I, as a landlord, do it myself, if I clean out the whole place myself, I really can't charge you. I mean, I tell landlords you could probably charge the tenant $15 an hour. So
Mm.
if I spend 2 hours of my time cleaning out the apartment, I can say, listen, I'm charging you $30 to remove all this trash that I physically removed.
Right.
That's typically a general rule that I use.
Got it.
If you're not going to hire someone, you can charge $15 an hour, which is what you would typically pay someone to actually do it.
That's a great point.
And
That's
that
reasonable.
is a
Mm-hmm.
general rule that I use. Yes.
Got it. Thank you. Thank you very much for that, Greg. So moving on to grounds to evict a tenant. What are some of the most common situations?
I wanted to. Oh, I'm sorry. I just wanted to go back.
Yeah.
I have one more thing I
Yeah.
wanted to say on limiting the liability, because
Of
we
course.
covered that a little bit. I always tell the landlords, if you're a landlord and you own a property in your individual name and not in an LLC, I always recommend that the landlord get a personal umbrella policy for whatever the value of the property is. So let me give you an example. I'm a
Mhm.
landlord. I've got one rental property. One rental property is worth $300,000. I've got my primary residence. My primary residence is worth $400,000, and then I've got two cars that are worth, $60,000. Okay,
Mhm.
I'm going to make sure I have at least a $1 million personal umbrella, which will cover all my assets. It'll cover my private home. It'll cover my rental property. It'll cover my automobiles and any other real property or automobiles that I own, or So, and obviously, if the value's higher, let's say I've got three rental properties, and the
Mhm.
three rental properties together are worth 1.5 million, then I make sure I have a $2 million umbrella. So you want to make
Got it.
sure you have a personal umbrella as a landlord. So if God forbid you're ever sued, you typically will have $300,000 of liability insurance on the property. If you get a judgment above that amount, if I've got a $2 million personal umbrella and I get sued, and the tenant gets a judgment for $700,000, because let's say someone gets injured. Let's say
Right.
they fell down the steps, they broke their neck, and they're suing me for $800,000. If they get a judgment against me for $800,000, my personal umbrella will protect me. Now, obviously, if I have an LLC and the property's an LLC, then I'd have no worry about that, because the LLC,
Right.
property LLC is separate from my personal assets, and then I'm not too worried. But if the rental property is in my name alone, it's very, very important that I have that personal umbrella to protect me from anything that happens, from people falling on the property and breaking their leg or whatever, then suing me. So I just want to make sure I covered that
Great point.
before we moved on to number 4, which
Absolutely. Mm-hmm.
was grounds to evict the tenant.
Mm-hmm.
So, okay, so the grounds to evict the tenant, typically there is a few common grounds that most landlords, when they call me up and they want to evict the tenants because of non-payment of rent, or
Yeah.
another common example would be the lease is up. So when a lease is up, that basically the landlord-tenant are now on a month-to-month lease. So
Mm-hmm.
the expired lease is still in effect, but the landlord or the tenant can now just give either 30 days notice to quit, or for
Right.
the tenant to leave. And typically in the leases that I write, the tenant will waive the notice to quit. So if your lease says the tenant's waived the notice to quit, you don't have to post anything. You just go right to the court and file for eviction. But if your lease says you've got to give the tenant, 15 days notice, which is what the statute says, or the lease is silent,
Mm-hmm.
you have to give the tenant basically 15 days notice to say, please vacate the property. If the tenant fails to vacate the property at the end of that 15-day period, then you can go right to the court. And again, in the counties, Delaware County, Montgomery County, Chester County, you can just file an eviction complaint. It's a one-page complaint. You can do it yourself without a lawyer. But obviously, you can always hire a lawyer if you want to. In Philadelphia, you could file it electronically, and in Philadelphia doesn't have district courts like the counties do. Philadelphia
Okay.
calls it municipal court. The rules are all the same, because the Pennsylvania laws are the same for all the counties. It's just that there's some procedural rules that are a little different in the jurisdictions like Philadelphia versus Delaware County. So just so we're clear on that. But basically, so getting back to the grounds,
Right.
not payment of rent, or the lease
Mm-hmm.
is up and you want the tenant out, are the two most common grounds. Also, disruption of property, or people not being on the lease. So, for example, I'm the
Yeah.
landlord. I come to collect the rent, and I go into the house and I see, oh my goodness, there's a big hole in the living room wall, and I'm like, oh my goodness, what's going on? And then the tenant will tell me some ridiculous story that's not even believable. But
Right.
anyway, so I feel that the tenant is destroying the property. That is also grounds for eviction. In addition, if the lease says there's no pets allowed, and then I come in again, I visit the property, and I say, oh my God, the tenant's got 2 dogs, and there's not supposed to be any pets on the
Right.
property, and that's grounds for eviction. Or people, there's only on the lease it lists all the occupants, at least the typically if it's 2 parents or one person will
Hmm.
sign for the lease. If their children or anyone else living with them will be listed also as tenants, even though the lease is only in the main person's name. So, for example, if I'm renting to a single mom with 2 kids, all 3 people are on the lease as occupants, but only the mom is the tenant, basically, just so we're clear on
Right.
that. So, and if I come in there and I see there's 10 people in there living there and there's only 3 occupants, again, that's a breach of the lease. That's grounds for eviction. Now, on the tenant side, I just want to cover that as well.
Yeah, of
Um,
course.
if the landlord does not maintain the property, like for example, in Philadelphia and Philadelphia only, the landlord must have a rental license. If a landlord does not have a
Oh,
rental license, he or she cannot collect rent from the tenant, and the tenant doesn't have to pay rent. That's not true in the counties, however. So the counties don't
okay.
require the landlord to have a rental license to collect rent, but it is true in Philadelphia. Also, the property's got to be habitable. What does that mean? It's got to have heat in the winter. It's got to have hot water, year round. It's got to have running water year round. So basically, if there's any major breach, if there's a hole in the roof, for example, that would be a breach of the warranty of habitability. So clearly, the tenant has rights as well. And if the property's not habitable for any of those major reasons, then the tenant can, again, once they give the landlord reasonable time to fix it,
Hmm.
they can pay for the repair and deduct it from rent, or they
Right.
can sue the landlord for the cost of repair. So that's their rights. Just so we covered that. Now
Gotcha.
I was going to go
Hmm.
into the eviction process, unless you
Right.
have any.
No, thank you. Thank you very much for that. I did want to ask you when it comes to, let's say, some damage in the property or more people than the amount of people that are in the lease agreement, how many days does the landlord usually give the tenant to either get rid of the pets or get rid of, or, tell whoever is living there to no longer do that? Is there like a
Yeah,
time
that's a
frame?
great. Yes, there's a great question. In the leases that I write, I actually put in there that if either party breached it, I'll go both sides. We'll
Hmm.
address your side first on the tenant side, or I'm sorry, the landlord side. So landlord discovers, oh my goodness, there's 10 people in here in the property, and there's only 3 people on the lease as occupants. The lease I write gives the tenant 10 days to remedy that breach. So landlord will
Gotcha.
tell the tenant, listen, I just realized you have 10 people living here. You're only supposed to have 3. You've got 10 days to get rid of the other 7. If you don't get rid of the other 7 in 10 days, we're going right to court to evict you on those grounds. And then let's switch the fact pattern. Let's say
Hmm.
that there's a hole in the ceiling and there's water coming in, a
Right.
clear breach of the warranty of habitability. Again, the tenant's going to tell the landlord. Landlord's going to have now for something like that. The landlord's got to get somebody over there. I'd say as soon as possible, like within 48 hours. If the
Gotcha.
landlord doesn't get anyone over there, I mean, it depends on the situation. I mean, clearly,
Hmm.
like for example, if there's a busted pipe and there's water coming into the house, that's an emergency situation. Obviously the tenant's going to notify the landlord, but he's also probably going to hire a plumber ASAP to fix that,
Immediately. Right.
and
Hmm.
the landlord's going to pay for it. But basically, in either case, if it's not an emergency situation, in the lease that I write, I give either party 10 days to correct any breaches. At the end of
Got
those
it.
10 days, if the party hasn't corrected the breach, then the other party can, if it's the landlord, they can evict the tenant. If it's the tenant, they can sue the landlord. And that's typically what I put specifically in the breach to address that issue, so that there's no confusion on that.
Got it. Makes sense. Thank you, Greg. So yeah, so now we can move on to the eviction process. Mhm.
Yes, yes. So on the eviction process, so basically, the and we'll do the counties first, and then we'll go back to Philadelphia because Philadelphia is just a little different than the counties. So when I say the counties, I'm referring to Delaware County, Montgomery County, and Chester County. So for those counties, every county's got a district court. The district court is what we call the people's court. It's small claims court. And basically in the district court, the complaint is typically one page, and the landlord will write in there if they're evicting the tenant, they'll write the reason for the eviction on the landlord-tenant complaint. And the landlord-tenant complaint, it'll say, the landlord will just explain, I'm evicting the tenant because they haven't paid me the last 2 months of rent, as an example. Or there are too many people in the property, and they're breaching the paragraph 25 of the lease, for example. And I also always tell the tenant, if I'm not filing the complaint myself, to attach a copy of the lease and the notice to quit to the complaint if the complaint doesn't waive the notice to quit. Because as I said earlier, in my leases, the tenant always waives that. But if the tenant doesn't waive it and you're the landlord, you have to prove you gave the tenant written notice to quit, and you either hand delivered it or sent it by certified mail, and you want to attach that information to the complaint as well as a copy of the lease. Because in the complaint itself, you're going to be referring to paragraphs in the lease, and that's why it's very helpful for the district justice to review that, because when you actually go to the hearing, we're going to have copies of the lease for everybody, for the district justice, for the tenant, as well as for ourselves. So basically, when we go to court and I represent the landlord is the plaintiff, the tenant is the defendant. And I make sure that we have 3 copies of every exhibit, and the landlord is going to typically be my only witness. And the landlord I will have 3 copies of all the exhibits I plan to present that day. I will have a copy of the lease, a copy of the notice to quit, any pictures of the property if we're saying that the tenant damaged the property, and the landlord will go first. The landlord both parties will be, anybody that's going to testify will be given an oath to tell the truth, the whole truth, and nothing but the truth by the district justice. And then the landlord will go first as the plaintiff. I'll just ask the landlord, why they're evicting the tenant. They'll authenticate the lease. They'll authenticate any pictures that they took of the damage. They'll authenticate the notice to quit that they gave if the tenant didn't waive that in the lease. And then we'll present our case in chief. And then the tenant, if they are represented, their attorney will cross-examine my landlord as my witness, and then I can always ask rebuttal questions if I so desire. But that's just what questions are asked. But basically, after before we actually get to court, though, when the complaint is filed, each party gets one continuance. So basically, so the landlord-tenant complaint is filed. Typically, you'll get a court date 2 to 3 weeks out, and basically either party gets one continuance. So, and typically when I go to file the complaint, or if the landlord does them themselves, I'll just tell them, when you file it, I file it in person in the counties, because you can't do it electronic. In Philadelphia, you can do everything electronic, but in the counties, you cannot. You have to go in person or mail it. So we typically either I'll go in person, or I'll send my paralegal, or I'll send the landlord to file it. And typically you can tell them what date you want. They'll give you the next date that's available, which will be 2 to 3 weeks out. If that date's not convenient for the landlord or myself, we'll just pick another date, and then that'll be our first date. And then notice will go out. In the counties, the sheriff will personally serve the tenant the complaint. And then once because if in the counties, if the sheriff doesn't personally serve it, they've got to send it by certified mail, and the tenant can always refuse it. So I always say, pay a little extra and have the sheriff serve it. That way, it'll get served. You'll definitely get service, because if you don't get service, you can't move forward. You need service first, and that's for all civil litigation, not just for landlord-tenant. So once we serve the complaint, the tenant will have the complaint. And then basically they'll, if the date is good for them, they'll show up. If the date's not good for them, they'll contact the court, and they'll get another date, and then we'll get that in the mail. But typically the day before the hearing, I always call the court just to make sure that the tenant didn't call, that morning or the day, because typically it's continued the day before. So I always say, typically wait till the afternoon before the hearing, call the district court, make sure that the tenant didn't ask for a continuance and you weren't notified, because that's never a good experience. And then once the actually date occurs, we actually go to court. As I said earlier, the landlord will testify with all the exhibits, the pictures, the lease, the notice to quit, and any other exhibits we use. And then they'll put their case on in chief. Then after that, the district justice has got 3 days to issue a written opinion. They'll and typically we're suing for both possession as well as monetary damages, whether that be back rent, property damage, or whatever the case may be. Once the district justice gives his ruling in 3 days, we'll get that in the mail. It'll also be on the electronic docket, so we can check the docket in 3 days if we didn't get it in the mail. And then basically, once we prevail, so let's say, for example, I'm the landlord, we prevail, we got 2 months rent. Let's say we got $4,000 in damages, as a round number, plus we got possession. The tenant has 10 days to appeal the possession and 30 days to appeal the $4,000 monetary judgment. When the tenant appeals, they have to pay our filing fee to the court of they're appealing to the Court of Common Pleas. So there's typically a filing fee of $320. So they've got to pay the $320, and they've got to pay the lesser of the judgment amount or 3 months rent, whatever the case may be. So in our example, we said they had a $4,000 judgment. Let's say that the monthly rent is $1,500 a month, just to round numbers. 3 times 1,500 is 4,500. Because 4,000 is less than 4,500, they've got to post $4,000, plus they've got to post a $320 filing fee for us to file a brand new complaint in the Court of Common Pleas. They've got to do that for possession within 10 days, for the monetary judgment within 30 days. They've got to serve us, they've got to serve the district court, and they've got to serve OJS or the Office of Judicial Support, which is at the Court of Common Pleas, which is the court administrator. So once they serve everyone and do everything they're supposed to do, then we would start. Unfortunately, the landlord's got to start over again. We got to file a brand new complaint in the Court of Common Pleas. We'll get a court date typically 9 months out in the Court of Common Pleas in the counties. And then when we get that court date, or after we file the complaint, the tenant has not 30 days to answer that brand new complaint. If they do not answer that 30-day complaint, if they don't answer the complaint within 30 days, then we can file to terminate their supersedious and then file the order for possession. Well, that typically takes about 3 days. Once their supersedious is terminated, it goes back to the district court, and we can file an order for possession. And it typically takes the sheriff about 3 weeks to show up and basically remove the tenant. And then I always recommend the landlord change the locks so the tenant can't get back in. Now I'm going to go over the process for Philadelphia, which is a little different.
Sure.
It's still the same in that the landlord still has 10 days to appeal for possession and 30 days to appeal for a money judgment. However, and the rules are still the same regarding posting either the lesser of the money judgment or 3 months rent. However, the tenant, if they are if they're unemployed, they don't have any money, they can file for porpoise, which just simply means that they can't afford to pay, and then they only have to post 1/3 of the judgment amount or the monthly rent, whichever's less. And they need to do that every month until that 9-month court date. So another example would be if they fail to post it with the Office of Judicial Support or Philadelphia's the court every 30 days, that 1/3 or the monthly rent, then we can also terminate their supersedious. And all that is just a filing that we file, and then we can go back to the district court, file the order for possession, and get them out in 3 months. Now, Philadelphia, it works kind of the same way. The only difference is before you can even file in Philadelphia, you've got to have a copy of the lease, which is typical, but then you also have to have a copy of your renter's license and also your Philadelphia business tax account number. If you don't have all those 3 things, you can't even sue the tenant in Philadelphia for back rent or for possession. So you need those things. And then if you didn't have a rental license, if you do get your rental license, you can only sue for back rent from the date you have a rental license forward. You can't go back. So if I rent it to you, so for example, if I rent it to you for 6 months and I just got my rental license a month ago and you didn't pay me any rent for that 6 months, I can only sue you for the 1 month rent that I had the rental license for. The other 5 months I have a rental license for, I'm out of luck. So I just want to make sure I stress that because I get that question quite a bit, as you can imagine.
Great point. Yeah, of course.
So so let me go over if you are, let's say that the tenant does not appeal
Hmm.
The tenant doesn't appeal in 10 days, then the landlord can then file an order for possession. And then and then after he files the order for possession, there's another filing fee he's got to pay. Then the sheriff will contact the landlord typically a week later. And then it takes another 2 weeks for the sheriff to actually go out there and remove the tenant. And on that specific day, the sheriff will tell the landlord, hey, I'm going out on, the 15th of September at 2 o'clock. And the landlord would meet them there. And I always tell the landlord, bring a locksmith with you, because as soon as if the tenant is still there, the sheriff will physically remove the tenant, and then the landlord needs to have the locksmith change the locks immediately so the tenant doesn't go back there an hour later and try to get back in the property. So that's very important. Okay,
Absolutely.
yeah, so okay, so I think so I think
That
I
was
covered.
that was
Yeah.
great. That was great. Thank you, Greg. Before we move on to tenant rights, can you give us a little bit of an idea as far as the difference, or what you would also suggest for someone who wants to do it himself or herself, as opposed to hiring an attorney for an eviction?
Well,
What are
here's
your
what I
thoughts on
always
that?
say. Here's what I would say. I've got landlords. I probably have about 30 clients that are landlords. So I've got quite a few of them. Some are doing it on the side. They have a full-time job and they just have a few rental properties on the side. For those type of landlords, they really don't have the time to do all this stuff. They want to have someone that knows what they're doing. They don't mind
Right.
paying me $1,800 or $1,750 to evict their tenant. So it really just depends on if you have the time and the expertise and you know how to do it. By all means, you can definitely do it yourself.
Hmm.
Don't have the time and you want someone to do it for you, like myself or another attorney, then you should definitely hire them to do it. It really just depends on, your expertise. Because
Gotcha.
I've got one landlord. He owns 30 properties. That's all he does. That's his full time job. He does evictions by himself all the time. He knows the laws as well as I do. He does a great job. So I always say for that guy, God bless him. He's doing a great
Right.
job. Keep doing it. And if he ever, and once in a while, he'll come to me with just some procedural questions.
Right.
I'm always happy to answer those. And I get phone calls all the time from people that aren't my clients to just have procedural questions. And if you call me up and ask me a procedural question, I'm always happy to help you. But obviously, if you don't know what you're doing or don't have the time to do it, then I definitely would recommend you hire a professional. Like an attorney like myself. That's really the general answer I give to that question, and hopefully that answered it
Got it.
for you.
Yes, yes, it does. And like one thing that I hear a lot here is that having a property management software company like DoorLoop in this case can come in very handy when it comes to finding leases, documents, receipts, any kind of records that you might need to bring to court. Because if you don't have proof, basically, if you can't find the original lease, you may not have a case, right?
Yes, that's absolutely correct. Yes, in fact, if you don't have the lease, then it's an oral lease, and then the statute will just control all those timelines that we talked about. So,
Right.
which are pro tenant, they're not pro landlord. So that's why the main reason for having a very good lease is to make sure that you are protected, and that all those timelines are spelled out, so that you're
Hmm.
not, and the tenant is waiving the notice to quit. I mean, I have a blog that I wrote, a few years ago on
Hmm.
the 7 clauses that every landlord should have in their leases and all that stuff, the waiving the notice to quit by the client, the Act 215, so that the landlord can garnish the wages, a 10% of the tenant's wages if they get a
Hmm.
judgment. Also, my attorney's fees being specific, saying it. If I've got to sue you, you agree to pay attorney's fees of $1,750 versus just reasonable attorney's fees, which only get you a few $100s. So all that stuff is very, very important. And again, yes, having a DoorLoop able to retain those documents for you is very, very helpful because you're going to need those documents. And that's
Hmm.
why also a picture's worth 1,000 words. So I always tell all my landlords and any tenants that call, when you first move in, you want to take pictures. And when you move out, you want to take pictures. This way you've got the before and after pictures. And that's if you've got the before and after pictures, you're going to do very, very well in court. So,
Great point. Yeah, absolutely. Plus, everyone has a camera on their phone nowadays. Like, why
yes,
not? Just take a
absolutely.
picture. Come
Just
on,
use
you're
your
there.
phone. Absolutely. Yes.
Terrific. And now moving on to, we already touched a little bit on tenant rights, but is there anything that you'd like to expand on as far as that?
Well, no, I would just like to say that basically, the biggest problem that I see that tenants make, or the biggest mistake I say, is is
Hmm.
not communicating with their landlord. Most landlords are very reasonable. And if you've
Hmm.
lost your job or you've got some kind of financial hardship, don't be afraid to call the landlord and say, listen, I've lost my job. I mean, I was a landlord myself for 10 years
Hmm.
up until I sold my rental property in 2019. So I was a landlord for 10 years, and I've had I've had several tenants over that time. And if a tenant called me up and said, listen, I got injured at work, I'm on workman's comp, I'm only receiving 60% of my normal pay. Can you, I'm going to be late on the rent this month. If they're a good tenant, I'll work with them. And I believe that most of my landlord clients will work with them. If you call me up and say, hey, I got injured, or I lost my job, I got laid off, and my
Hmm.
unemployment's only, 70% of what I was making, a landlord will work with you if you work with them and you're honest with them. I think the
Got
biggest
it.
problem that tenants make is they don't communicate, and then they just don't pay the rent. And then the landlord's like, oh my, and they don't return the landlord's phone calls. Then the landlord's like, oh my goodness, the tenant's not paying rent. They're not calling me. They're not telling me why they're not paying rent. And that's a big concern. So
Got it.
obviously, the biggest thing I would tell everyone is communication is critical in
Communication.
every relationship, both business and personal. And if you keep those lines of communication open, you'll have a lot less issues. And also,
Hmm.
if you want to just move, just talk to the landlord. Say, listen, I know I gave you 90 days notice, but if I can move in 60 days and I'll help you find a new tenant within 60 days, a lot of landlords will work with you in that respect as well. So, really just keep those lines of communication open are very, very important.
Got it. Got it. And you mentioned you represent a lot of your clients are landlords. Do you also represent a lot of tenants? And what are some of the most common cases that you get?
Yes, well, that again, that's another good question. I basically would say that 80% of the time I represent landlords, 20% of the time I represent tenants. And when I represent a tenant, it's because the landlord acted egregiously and was not a good landlord. And it was a situation where they neglected the property, repairs were not done timely, and the tenant has having to do the repairs themselves and having to sue the landlord because they didn't do the repairs,
Got it.
or there was some other breach, or they never had a rental relations, or there's something wrong there. So that's typically the makeup of what I do. I mean, my philosophy is
Hmm.
always, I don't care whether you're the landlord or the tenant. If you're doing the right thing and the other party is not doing the right thing, I'll be happy to represent you as long as there's no conflict. Obviously, I mean, just so you
Right.
know, if a tenant calls up and they're a tenant of my current client, I can't represent them, obviously. But
Makes sense.
assuming there's no conflict, if the landlord is not acting correctly, and the tenant has a real cause of action, I will be happy to represent the tenant. I have represented tenants in those exact circumstances. Absolutely.
Terrific. Thank you, Greg. And we're almost done. Let's touch a little bit on squatters' rights laws. Do you get that a lot? Do you get that kind of
I don't.
situations,
Yeah, no, I,
cases?
I don't get it a lot. I get it periodically,
Okay.
and it's typically for people that have vacation homes in Pennsylvania. Here, a lot of people have homes in the Poconos or in the mountains, as we like to call them, which is in the central part of Pennsylvania. Near Jim Thorpe or the Poconos, et cetera. And
Okay.
basically, as squatters' rights, I guess the most important thing. Well, as soon as I hear squatters' rights, I always hear about adverse possession, and what that is that basically if someone finds an abandoned property or a vacant property and they break in, and they start living there and they change the locks and they start receiving mail there, now they've got tenant rights. Unfortunately, now let's change the fact pattern a little bit. Let's say that
Mm-hmm.
I've got a house in the Poconos. It's a vacation home, and I only go there in the month of December to go hunting,
Mm-hmm.
okay, or fishing or whatever I
Mm-hmm.
do there. So
Right.
basically, the I really fish. I don't hunt, but I do fish. I love to fish, but that's a separate issue. But anyway,
Amazing.
so basically, if someone breaks into that property, my property, and they break in at the end of November, and I show up there in December, and I'm like, who the heck are you? And they say, oh, I've been living here. This is my place. And I say, no, it's not. And I immediately call the police. The police show up. I explain to them that, hey, this person broke into my property. I'm the legal owner of the property, and the person doesn't have any mail and can't prove that it's their property. The police will arrest them for trespassing, because that's exactly what they are. Now let's change the fact pattern. Let's
Mm-hmm.
say that I went there the month of December, and then I haven't gone there for a full year. Someone broke in February. I was unaware that they broke in. They start receiving mail there. They change the locks. I go up there in December and I can't even get into my own place. I call the police. The police show up and they say, "Oh yeah, this is my place. See, I get mail here." Now all of a sudden they got landlord-tenant rights, even though, in my opinion, they're still a trespasser. However, because they're receiving mail there and they've been living there for a while, they can prove that they get landlord-tenant rights. Then I've got to evict them just like I would any other tenant. And unfortunately, I don't have a lease, but I would just write in the complaint that, hey, I would call them a trespasser because they basically broke into my property. They didn't have my permission, and they're squatters in essence.
Right.
So I would go through that eviction process just like I would in any of the other counties, and I would get them out that way. And that's basically now. That's really my view on squatters, and that's why I always tell everyone, no matter where you live, if you got properties all over the country, you want to make sure you've got a real good neighbor who's checking up on your properties on a monthly basis, if not more frequently, so that if, God forbid, someone breaks in there and they see, "Oh my goodness, there's someone in there I don't recognize, let me call Greg," and they'll say, "Oh, hey, Greg, some guys in your property, I don't know who the heck they are. They've been there for 2 weeks." And then I can go on alert, and then I can go there. Also, have have a good alarm system on those properties. Have cameras. There's a lot of great cameras out there. Blink. I use Blink on all my properties. So if I'm not there, I can check on my phone every day to see if someone's there. And that's another good idea as well. You want to make sure you monitor all your properties, especially the properties are in other states and they're not nearby. And so that, God forbid, if someone tries to break in, you know immediately you can call the police and get them arrested and get them out of there. So that's really my advice to avoid squatters, because that would not be a good experience, obviously.
Yeah, it's a great point. And what you mentioned about the cameras, I think it's key, especially because nowadays with technology, you can even watch whatever's going on in your house from your phone, right? Sometimes
Yes,
like the doorbell
absolutely. And I
other
use
cameras.
Yeah, absolutely. I use Blink, but Ring. There's a million competitors now,
Right.
and you can have multiple properties on one phone, and I check it every day. Because you want to make sure that, God forbid, someone breaks in, you want to be the first one to know it. And you also want to have a good alarm system too. So if someone breaks in, the alarm will go off and then the police will be automatically alerted. So
Yeah,
that,
absolutely.
so those are very good ideas to prevent, again, just an ounce of prevention, preventing that pound of cure, is worth a pound of cure because it prevents all those issues.
Right. Terrific. Thank you, Greg. And just to wrap it up, let's talk a little bit about, I'm sorry, were you saying something?
Oh, no, I was going to say, we're going to go into rent increase laws.
Yeah, rent increase laws. Yeah, let's talk a little bit about that.
Okay, so unlike the New York, Pennsylvania does not have rent control laws. The statute says that if you're going to increase the rent and it's not addressed in your lease, you need to give the tenant at least 30 days notice. Typically, I do put that in my lease. And in most of my leases, I put 60 days notice or longer, just depending on what the landlord wants. This way, you give the tenant plenty of time, because no one likes surprises. I don't like surprises. And so if I'm going to raise the rent, I always tell the landlord, if you can give the tenant 90 days notice, that's even better. But at a minimum, I always put at least 60 days notice in the lease. This way, the tenant's got plenty of time to plan their budget, so they're not upset that they got a big rent increase and, that's being sprung on them at the last minute, obviously.
Terrific. Wow, thank you very much, Greg. And just before I show all your contact information, can you tell us a little bit as far as, maybe price ranges of, what someone may be looking at if they would like to hire you as a landlord or even as a tenant?
Sure. Well, yeah, I'll go over a couple of common prices. The first is, as I said earlier, the rental applications for Pennsylvania landlords is free. It's on my website. Also, the notice to quit is also free. That's on my website. And for the leases, I charge $450 for a lease. So if you want to buy one of my leases, I'm happy to sell that to you.
Amazing.
And I can sell it to you both. You'll get it both in digital form as well as paper form. So you'll get it in Word, so you can keep changing it and using it over and over again.
Right.
I do update it every few years, obviously. So if you've been using one of my leases from 5 or 10 years ago, you probably need to buy a newer one, because we've made changes since then, because I do keep track of all the landlord-tenant law changes. But the lease is $450. And then obviously, if you want to hire me to evict a tenant, I charge $17.50 to do that in the district court. And then also, I charge a little more. I charge $2,400 to go to the court of common pleas. So if you've already done the district court and the tenant appealed, now you want to hire me to go to the court of common pleas, I charge $2,400. So, and those are just retainers, because I'm charging basically $380 an hour. So so when you give me $2,400, you're just really prepaying for 6.5 hours of my time, just so you do that. And that also, there's costs on top of that too. So obviously,
Right.
but the good news is that on an appeal, if the tenant appeals, they're going to pay your $320 filing fee, so we don't have to pay that, which is good news. But I do have to pay a $50 entry of appearance fee, which would be, part of my fee, just so you knew that.
Got it. Thank you very much, Greg. I'm going to go ahead and share your contact information, but if you'd like to tell everyone your email and phone number, that'd be great.
Yeah, that'll be great. Yes, my email is right there. It's Gregory at SpadeaLawFirm.com. My phone number is 610-521-0604. My website is SpadeaLawFirm.com. So feel free to go there. On the resource page, under real estate, there's a bunch of great information. I also do real estate tax appeals as well for the counties. I don't do Philadelphia. So we do that in the summer, because the deadline's August 1st. So in June, if you think your property is overassessed and you'd like to lower your real estate taxes, feel free to give me a call, and I'll give you a free, we'll look at your property and see if you're a candidate for that, and it won't cost anything. So, terrific. And maybe we'll do a future blog on that, or a future webinar.
Yeah, that'd be great. All right, Greg, thank you very much. Let me go ahead and stop sharing my screen. And before we go, are there any final thoughts that you'd like to share with some of our viewers, landlords and or tenants?
No, I want to thank you for having me, and thank everyone for listening and looking at this. And as I said, I hope I answered some of your questions. And if it generated new questions, as I said, feel free to give me a call. I'm always happy to answer any questions that you have regarding procedures for the eviction process, or tenants' rights, or anything else.
Thank you very much for that, Gregory. That was a lot of very useful information. And thank you very much for joining us today. And remember, if you're a landlord or a property manager and you haven't tried DoorLoop yet, go ahead and request a demo today. You can do that on our website at www.doorloop.com. All right? So once again, thank you very much for joining us today, and we'll see you on the next one.